Counsels are taught in law school the etiquette of professionalism, but not to bully courts. I still opt to mentor counsels on this part of our daily learning processes. Ironically, the application is of one accused person, yet there are two accused persons in this case. Why is a narrative being occasioned? What is the ultimate of this narrative? The court takes judicial notice that while there is no stay order, underline the word no stay order, as per today, the 23rd day of October 2025, from the said cited courts by counsel for the accused person, the court cannot on its own motion stay its proceedings. This is a magistrate's court. Seemingly, the parties hearing, specifically the first accused parties, are intentionally playing victim, and this commenced immediately accused one was put on his defense. It's quite sad to note that from the onset of this matter, the first accused person has sought adjournments and was the cause in delay of this matter. This again is replaying itself, and sadly so. The court is alive and this matter is sub judice and does not stay orders. Asking the court to recuse herself must meet the criteria to do so. Most importantly, these are issues which need legal recourse. This court will be bigger than the assertion deponed by counsel and his client. Has this court been served with a stay order up to now? No. If the above are to make the court look bad, I emphasize in the same breath that counsel hearing should express professionalism when penning down the thoughts of his client. Be kind as a professional and always uphold the rule of law while engaging. Clients come and go, but as lawyers practice is the constant north. This court cannot stay its own proceedings because parties have scored my proceedings to be below par, or so to speak. This court cannot dislike itself because parties do not like body language, and I quote your words, but this court is under oath of office to be above all allegations as the case may be, and this is what I uphold before God and the office that I hold. In a nutshell, the application is properly executed to intimidate. The court will be careful not to be annoyed with counsel or his client, but express mentorship that counsel should be above board and stable before penning such allegations, which literally are his self-lamentations. We have read and seen our names being dragged into public gallery, but we choose the oath of office. We have been discussed in parliament, but we are not politicians. We choose the oath of office and the constitution. Now we have been mudslung as the application hearing. Maybe, but again, we choose to affirm the oath of office, the constitution, the rule of law, and above all, God. Having said the above, two issues stand out in this application, which has basically been mentioned above. Can it take 2 years for this court to have towards the tail end that the said allegations are made? Is it properly sound to bring this application when the said applicant is now on his defense? This case has two accused persons, yet only one accused person has brought this application. This is notably not the highest court of the land in Kenya, but the initial lower court. In view of the foregoing, and I quote, on the recusal of judges and judicial officers, the Judicial Service Commission made the Judicial Service Code of Conduct and Ethics, Regulations 2010, pursuant to Section 47(2)(a) of the Judicial Service Act, Section 37 of the Leadership and Integrity Act 2012, and Section 1 of the Public Officers Act 2003. Under Regulation 21A, a judge may recuse himself or herself if any proceedings in which his or her impartiality might reasonably be questioned where the judge is, and for purposes of this matter, judicial officers. 1. Is a party to the proceedings. 2. Was or is material witness in the matter in controversy. 3. Has personal knowledge of disputed evidential facts concerning the proceedings. 4. Has actual bias or prejudice concerning the party. 5. Has a personal interest or is in a relationship with a person who has a personal interest in the matter of in the outcome of the matter. Number 6, has previously acted as counsel for a party in the same matter. Number 7, is precluded from hearing the matter on account of any other sufficient reason. Number 8, or a member of the judge's family has economic or other interest in the outcome of the matter in question. Regulation 21(2) requires that recusal by a judge or judicial officer shall be based on specific grounds to be recorded in writing and as part of the proceedings. This is supplemented by Regulation 21(3), which forbids a judge from recusing him or herself if the circumstances set out therein. The said regulation that the court must guard against its independence and not to recuse itself in circumstances that do not merit. However, in the circumstances where there is a merit, either due to surrounding facts or appearance of bias, a judge should recuse him or herself. If, for example, a family member is involved, the court should not wait for an application for recusal. This even occurs in cases where the judge's conscience points to a discomfort due to a relationship, either legal or otherwise. However, where there is no merit and the same is based on unfounded speculations, the court should and must not recuse itself. Under the Regulation 7 of the Judicial Service Act and Conduct, Regulations 2020, a judge or judicial officer shall exercise judicial authority independently and shall 1. Uphold the independence and integrity of the judiciary and the authority of the courts, maintain an independence of mind in the performance of judicial duties, take all reasonable steps to ensure that no person, forum, or organ of state interferes with the functioning of the courts, exercise judicial function on the basis of the judge's own assessment of the facts of the case in accordance with the conscientious understanding of the law and without reference to any extraneous influences, and exercise judicial function without being influenced by personal feelings or prejudice or bias. Independent exercise of judicial authority is affected by bias or ill will against a party. It is also compromised if the court succumbs to machinations and intimidation by parties. However, where a party wants to waste the court's time or otherwise forum shop, the court should be firm and clearly indicate so to parties. Unnecessary application for recusal is an affront to the independence of the judiciary and the judicial independence of the judges or judicial officers. On the other hand, a bias court is also noted. In the case of the National Water Conservation and Pipeline Corporations versus Rujji and Partners Consulting Engineers and Planners Limited 2021, the court stated as follows: I cannot think of a more eloquent exposition of the law on recusal of judicial officers than the exposition provided by the Constitutional Court of South Africa, President of the Republic of South Africa, and others, versus South African Rugby Football Union and others, which indisputably articulated the proper approach as follows. The question is whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear an adjudication of the case, that is, a mind open to persuasion by the evidence of the submissions of counsel. The reasonableness of the apprehension must be assessed in the light of the oath of office taken by the judges and judicial officer to administer justice without fear or favor, and the ability to carry out the oath by reason of their trainings and experience. It must be assumed that they can disabuse their minds of any relevant personal beliefs or predisposition. They must take into account the fact that they have a duty to sit in any case in which they are not obliged to recuse themselves. On the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite for a fair trial, and a judicial officer should not hesitate to recuse herself or himself if there are reasonable grounds on the part of the litigant for apprehending the judicial officer, for whatever reason, was not or will not be impartial. The test is that absolute neutrality is something of a chimera in the judicial context. This is because judges are human. They are unavoidable the product of their own life experiences, and their perspective, thus derived inevitably and distinctively, informs each judge's performance of his or her judicial duties. But colorless neutrality stands in contrast to judicial impartiality, a distinction the above-cited decision vividly illustrates. Impartiality is that quality of open mind read, persuasion, without adherence to either party or to the judge's own predilections, preconceptions, and personal views. That is the keystone of a civilized system of adjudication. Impartiality requires in short, a mind open to persuasion by the evidence and the submissions of the counsel, end of quote. And in contrast to neutrality, this is an absolute requirement in every judicial proceeding. This is because a cornerstone of any fair and just legal system is the impartial adjudication of disputes which come before courts and other tribunals. Nothing is more likely to impair confidence in such proceedings, where on the part of litigants or the general public, than actual bias or the appearance of bias in the officers who have power to adjudicate on disputes. In the Attorney General of Kenya versus Professor Anyang' Nyong'o and 10 others, ESCJ application number 5 of 2007, the court stated, and I quote, "We think that the objective test of reasonable apprehension of bias is good law. The test is stated variously, but amount to this: do the circumstances give rise to a reasonable apprehension in the mind of the reasonable, fair-minded, and informed member of the public that the judge or judicial officers will not apply his mind to the case impartiality. The test is not what the litigant feels. It is a member of public who is not only reasonable." In the case of Rachonyo and Rachonyo Advocates versus the National Bank of Kenya Limited 2021, Justice D.S. Majanja, and may soul rest in peace, held as follows, and I quote, "In Philip K. Tunoi and another versus the Judicial Service Commission and another, court civil application Nairobi, number 6 of 2016, EKLR, the Court of Appeal adopted the test of recusal propounded by the House of Lords in Porter versus Magill, 2002. The question is whether the fair-minded and informed observer have considered the facts, would conclude that there was real possibility that the tribunal was biased, end of quote. The same position was taken by the Supreme Court by Ibrahim J. in Jasbir Rai and 3 others versus Talokan Singh Rai and the 4 others, Supreme Court of Kenya petition number 4 of 2012, where he observed, and I quote, "The court has to address its mind to the question of whether reasonable and fair-minded mind sitting in court and knowing all the relevant facts would have a reasonable suspicion that a fair trial for an applicant was not possible. If the answer is to the affirmative, disqualification is inevitable. In this matter, a fair-minded, knowing the circumstances of this case, will not have any doubt that the case will be heard fairly." Now, the application for recusal hearing is based on speculation, conjecture, sheer paranoia, and falls short of the legal threshold to recuse from handling the case. Again, in Justice Professor Dr. Sifuna, in Bituman Limited versus SBM Kenya Limited and another 2003, unreported, stated as follows, and I quote, "The bedrock of this determination rests on that the recusal is necessitated where it is proved beyond peradventure, speculation, conjecture, and sheer paranoia that a judicial officer will not impartially handle a case before him as a result of actual bias or a reasonable apprehension thereof, and never on unfounded on unreasonable apprehension. Where an application is based on apprehension rather than actual bias, the apprehension should be that of a reasonable person and must be assessed in the light of the true facts as they emerge at the hearing of the application." In the Supreme Court of Uganda, in Uganda Polybags Limited versus the Development Finance Company Limited and others 1999, was of the view that litigants have no right to choose which judicial officer should hear and determine their cases, since all judicial officers take oath to administer justice to all manner of people impartially, without fear, favor, or ill will, and the oath must be respected. The case applied in all cases of apparent bias was whether having regard to the relevant circumstances. I cannot think of a more eloquent exposition of the law on the recusal of judicial officers. I'll go to the ones that tail end. Second, the other is inbuilt aspect of the test is that, and I quote, absolute neutrality is something of a chimera in the judicial context. This is because judges, as I've said earlier, are all human. A cornerstone of any fair and just legal system is the impartial adjudication of disputes which come before courts and other tribunals. Having said the above and cited the above legal authorities, all in the superior courts, within and without the court, orders as follows. Number 1, the said application for recusal is disallowed and the said accused continues with his cross-examination, that the court will give 2 dates for the conclusion of the defense hearing of this matter. This court so submits. And before I pen off, and with finality, this case has been during my pendency when I was recently promoted as a chief magistrate, and this speaks volumes, and equally nominated as the Judicial Officer of the Year award. Has these 2 bodies been compromised to align with the said allegation? Absolutely not, but we mentor the legal profession moving on. The rule of law proceeds. This ruling is read and delivered in open court this 23rd day of October 2025 at 9:30 East African time. The proceedings are ready. Yes.
Oh, now the only issue that I wanted to go on record is that for A2, we've been served with the application this morning. That is the 23rd October 2025. And we had not taken directions in respect to that application.
It was the application. I got mine in the portal, so I had to respond. So I don't know what they wanted. I don't know what your application is all about.
It's not. I just want that to go on record.
Yeah,
that at the time you delivered the ruling,
yeah,
we had not taken directions in respect to the hearing.
You're parcel of it?
Of this one, because you see, we've been served this morning.
Is it the same one?
The application?
Yeah.
Yes, it is.
But I read through. It's only for accused.
It is only in respect to accused 1.
Accused 1, yeah, not
yes.
2. Accused 1.
Not
yes.
2.
Okay.
Yes. But then our sentiment seems not to have been captured by the court. I do not know how we square that.
Are you part of it?
Of the application?
Yes.
As a party, we've been served with the application.
Yeah, so what do I do with that?
That's why I'm saying, let it just
yeah, it's on record that you've just been served,
that
right?
we've been served with the application.
Yes.
And we have not taken those directions.
I don't know what directions. Did they want direction from you, or this was addressed to the court?
I think it was for the parties that are before the court.
Are you part and parcel? Because I've seen there's only one applicant.
We are the respondent. We are the second respondent.
Yes, because you're all parties, yes. But yours, you've not been mentioned. So I was addressing to the court which has been mentioned, and I had to put, because the directions taken last week,
yes,
that all parties to finalize, and then this date. So when I saw it, and it came under certificate,
yes,
I had to. It was in my portal.
I'm well guided.
Thank you.
What was of concern is that as the second respondent, we hadn't put our views in.
Yeah, I think the directions were very clear last week, and this was directed to the court as a person.
As a person.
As a person.
I'm well guided.
Right. Prosecution.
Your Honor, we are much obliged by your ruling. Your Honor, on 16th October 2025.
Okay. How long? How short? I think in the ruling there are 2 days. We were to cross-exam.
We had indicated we are taking 2 days, 2 hearing days.
2 hearing days.
Yes, yeah.
And kindly allow all the courts that you've mentioned to do their work. Kindly. That's what I ask of you. Kindly. That's the mentorship that I've spoken about. And I'm not annoyed. Just allow the courts to do their work. Even the most stupid courts will write paper and pen. I don't think that the judicial service have employed people who are so badly off. So whichever the courts, the many courts that have been mentioned in this application, please allow them to do their work. That is what I've asked of you. And counsel, please also direct your clients to be sober-minded. At the end of the day, I'm a mother. It hurts me when such things are said about me. And number two, I thought when I empathized with a particular application, council don't write, because those are the things that you people write and then they throw back to me. Just don't write. I'm saying it, I'm not writing. This is the part of mentorship I'm saying. And also don't record, because I look at every other thing. I'm thinking that even if I say good morning, it will be recorded that the magistrate said good morning and she was not happy. Or the magistrate put on address which was not good, and that she said that. Don't do that. Don't preempt. It is wrong. Let's all wish people well, and let the courts that you've mentioned do their work. I cannot say anything about the higher courts. But the day you serve me with a stay, at least I know that I don't have to proceed. Okay? I have nothing against the both of you or all of you. I have nothing against you, and I say it so loudly. And that can go on record. But let's not put emotions in some of these cases. I wish I had a senior counsel here, but there's none. Is there any senior counsel in this court? None. Well, mentorship is key. You see, sometimes we err, but we learn from each other. Yeah. You're amused, counsel? No. Or you want to say something?
Well, I'm also being mentored, I'm guided.
You're guided, yeah. We learn every day, don't worry. We learn. And that is why I had to get my, from higher courts. Okay, can I get directions? How long, short? Prosecution, it was close.
Yes, close.
How long do you think you take?
Yeah, about 2 hours.
2 hours, then that takes us to RE.
Yes.
RE for A1.
Yes,
RE A1.
I think depending on how long they go.
So let's take or leave maybe 4 hours. 2.
I think that would be a fair.
Okay, 2. Then we come to you, counsel.
I had indicated maximum I would take maybe 1 hour and 30 minutes.
Okay.
But if just to be on the safe side, maybe we can peg it at 2
hours.
2 hours.
Okay.
For
A2,
that is examination in chief.
Examining
Oh, okay.
That's for A2.
Yeah.
You're the one who you said is not part of this.
Yes.
But we are that has passed out under the bridge.
Yes.
So direction. So 2 hours max. Then cross
about 30 to 40 minutes.
30. We are at 2 half, and then
if he does it in 40 minutes, then I wouldn't take more than 20.
Yeah. So we are talking about a day or 2,
Yeah.
or we can take max 2 days.
2 days.
Okay. When do you close, council rule? When do you close in December? When do you close in December? From the or you're around?
15. But I'm around. If in December, you can.
You're equally around?
Yes, Your Honor.
Okay.
I'll take it in December.
Okay.
That is between the 10th
and
between the 10th and 8th, around 18th.
18th.
Yes.
Okay. So can we do it on let's have the week commencing, we will see prosecution. You have other matters, but this is towards the tail end.
Yeah.
We can have 16th, 17th, 18th. We can balance.
16th,
17th and 18th.
17th
And 18th.
and 18th.
Yeah. 16th, 17th,
Yeah, you can have that.
and 18th.
That is convenient for A2.
That's convenient for everyone.
Okay. Prosecution, that's okay with you also?
That's okay, Your Honor. Much obliged.
So the dates have been taken by consent by all parties. And my parting shot would be, let us disagree in law, but not on any other issue. Let's just disagree on law, but let's not call each other names. It's wrong. That part I will not want to go that way. It is wrong. Because these are matters of in record. How do I say that the body, how do I defend my body language? You'll read if you've not read, counsel. It's wrong. It's totally wrong. But I still opt to mentor. And lastly, I forgive the allegations put against me. I forgive. I forgive. And I deeply say so, I forgive.